Good morning and welcome to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in beautiful Peckville, Pennsylvania, and I am right here each and every week at this time on this station to bring you, the Pennsylvania landowner, the information you need regarding natural gas development. And of course, and as always, I, Doug Clark, never have, never will, have not, do not, will not represent gas or pipeline companies. My practice is focused on representing Pennsylvania landowners and oil and gas right owners. Again, never represented the company, never will. Pull the Brinks truck up, I will turn it away. We need people fighting for the Pennsylvania landowner, and let me tell you, I honestly love doing it. Now, I am excited to talk about today's topic just because it's so important. I've talked about it before, and I'm going to keep talking about it. And listen, I'll give you a break. It's not about just the shut-in issues, but what it's about, and I've talked about this before, is this incredibly powerful word, ratification. The word is ratification. And I would say that I would recommend everybody listening to focus on the first three letters of the word ratification, which, by the way, are R-A-T, rat. So, when you read the word ratification, I hope in your mind, if you see the word ratification in any document that's ever presented to you, I hope you've listened to this show, and I hope that you think rat, 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 alert, red flags, ratification. This is what that guy was talking about. And what are we going to do? We're going to put the pen down. We're going to pick up the phone because rats, as a general rule, are not good. So, ratification, I want you to focus on rat because I want you to understand that ratifications, by just signing them, in my opinion, is not good. Not at all. And in fact, can be, and unfortunately many people will sign these, and it will be devastating for them and what they could have done. And I don't say this of speculation. I say this because I'm already seeing it, and I've seen it, and I know darn well that I am going to see a lot more of it in the future. Ladies and gentlemen listening, please remember this and tell your friends, tell your neighbors, and even tell your enemies. Ratifications, put the dang pen down and pick up the phone. This is going to be, and this is a speculation prediction based upon a whole lot of experience, this is going to be the number one issue affecting the majority of landowners out there who are currently leased. There are two things that you are going to see. Mark my words, you are going to see them. Not everybody, but I believe hundreds of people will be seeing documents presented to them. Ratifications, amendments and ratifications, modification and ratification, and also top leases. You, ladies and gentlemen, are going to start to see these. Let me explain why. Many people have signed leases from the early 2000s up till, let's say, 2015 even. And those leases had what we call primary terms. A period of time, usually 5 years, sometimes 10 years. Sometimes the primary term is 5 years, but the company can extend it to 10 years. But people have signed these leases, and that 5-year or 10-year primary term has now expired. It has passed. You're listening to All Things Marcellus with me, attorney Doug Clark. So the primary term has passed, and you're not seeing royalties. And if you're listening to the show, I know that there are literally hundreds and probably into the thousands of people who are in this position where you signed a 5-year, a 10-year, or a 5+5-year primary term lease. That period has now expired, and you are not receiving royalties. And my friends in Tioga County, you know that most of you are being held because they drilled a vertical well, and now they're sitting on it, and they're paying you yearly shut-in payments. So let me tell you, ladies and gentlemen, the market has tanked. The gas market is bad. That's where we're at. Well, as a result of that, there are negative consequences to the landowners. If you're getting royalties, your royalties aren't nearly as high as they would be if gas prices were higher. Pretty simple stuff. But there can be a positive consequence of this low gas price and lack of production to a group of hundreds and probably even over 1,000 landowners. What do I mean by that? So here you are sitting there. And again, I'm sure there's hundreds of the people listening to the show that are in this position. Your primary term of your lease expired in 2010 through, let's say, 2015. Your primary term has expired. You're not getting royalty. You're getting shut-in payments. Well, let me tell you what I think is going to happen, and this is based upon doing this every day. I think what you're going to see is you're going to continue to get shut-in payments until you do something about it if you can. And that's why I say I do these reviews and consultations, free reviews, evaluation, and consultation if you're shut in for more than 8 years by a vertical well and you have 100 acres or more. But the point is, this is the point I want to get across. For all of you people who are getting shut-in payments year after year, do you think that's going to stop? I am going to tell you in my strongest opinion, it's not going to stop unless you do something about it. Meaning, your lease very well may have expired, but the company is going to, in my opinion, and especially SWEPI, is going to continue to pay you shut-in payments after your primary term is over, and they're going to do that every year. And look, you know you're seeing this all the time. I deal with this all the time. You're going to get these shut-in payments year after year. You're not going to, some people, most people, unfortunately, aren't going to look into this. They're not going to do anything. They're just going to accept these $5 per acre, $1 per acre per year shut-in payments and just accept it. I'm going to tell you now, you shouldn't. You shouldn't. You need to look into this and find out if it's proper, because if you don't, the company is going to keep making these payments and saying that they're holding your lease, even though your primary term of your lease may have expired in 2010, 11, or 12. And you people, you're the ones I want to hear. I want to hear from anyone that has a case, but you're people I want to hear from, because you didn't sign a lease to be shut in for 8 and 10 years after the end of your primary term. You didn't sign a lease in the year 2000 thinking you'd be in the year 2020 and never see a dime of royalty. You didn't expect that. You weren't told that. And the question is it legally proper? Does your lease allow that? And I'm going to tell you, in some cases it may, but in many other cases it may not. And the question is, where do you fit in? And that's why I do these reviews and evaluations. Do you have a claim to terminate your gas lease? You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station for All Things Marcellus. We're talking about ratifications, and the basis is, again, we have all of these leases where the primary term has expired, literally hundreds upon hundreds. The primary term has expired, and the only thing that you are seeing as a landowner is a yearly or quarterly shut-in payment, typically $5 an acre. What are we going to see? My opinion, but boy, do I believe this. I believe this, and I very strongly believe it. What you're going to see is that's going to continue to happen. And then, if you do nothing about it, it's going to continue to happen. It's going to continue to happen. And the company may just go ahead and drill. And someday, maybe it's 5 or 10 years into the future. Maybe it's 3 years into the future, 2 or 1. But someday, they may start producing gas. And they're going to pay you, according to your old lease, the terms of your old lease, typically 12.5% royalty, typically full deductions, and they're not going to have to pay you a new bonus. In my opinion, in many cases, that's going to be very wrong. The other thing that's going to happen, in my opinion, and I am extremely confident in this opinion, the companies are paying you these shut-in payments, and now they're getting ready to develop. So what they're going to do, especially if you have a well pad on your property, but then to other people, I'm confident of this as well, who are in the unit, they're going to approach you for an amendment, a modification, and most importantly, a ratification. And why are they going to do this? Well, the ratification is the key document that they want to use to correct any prior issues that existed. If they breached your lease, if your lease should have terminated, if your lease in fact did terminate, but they did not release it or give you back your property, the ratification is their vehicle. The rat is their vehicle to correct everything. So I say, look for ratification. Rat. Well, what happens is the companies, I'm going to tell you, they listen to this show. I know they do. They tell me sometimes. They listen to the show. They hate that I am telling you ratifications. Watch out for ratifications. Ratification. They hate it because they know that's their big weapon. They hate it. But I don't, who cares? We need this information to you. But they're smart. So what are they going to do? They're probably not going to put the word ratification in the heading of any document they want you to sign. They're going to be creative. Hey, Doug Clark's telling everybody, watch out for ratifications. Don't put ratifications in the heading. If I were to work for a gas company, which I promise you I never will, but if I were, I would tell the company, listen, we need to get ratifications. But don't tip off the landowner what we're doing. Let's bury the ratification language in the document. Because once they sign it, that's what speaks going forward. The four corners of the document. What is written in the document is what controls. So, we don't need to highlight ratification. Let's bury it in. Bury it in this document, which is loaded with legalese and terms that people don't understand. Let's bury it in this document. We'll get them to sign, and pow, we got it. We have now corrected potentially a dead lease. We've revived it. We have corrected any potential breach claims. We have eliminated the landowner's ability to negotiate a new lease, And we don't have to pay them any more money for a bonus. We don't have to pay them any higher royalty percent. We don't have to negotiate royalty calculation or any other terms. Ratifications are the most powerful documents right now, in my opinion. And so that's what they're going to try to do. That's what I would do if I were them, which I won't be. But that's what I would do. And that's what they're going to do. And that's what they do already. It is what they do already. And you're going to see it. Mark my words. The question is, what are you going to do about it? Are you going to sign? Or are you going to keep taking yearly shut-in checks and just continue to be stomped on year after year? Are you going to take those? Or are you going to say, hey, let me find out if this is right? Are they allowed to do this? I wrote 2 letters within the last 2 weeks where there are shut-in limitations in the lease that said this lease had to stop or it cannot continue past 3 years of shut-in time. People send me the situation. I look at it, again, reviews and consultations, to say, this is unbelievably clear. You have been shut in for 5 years. Your lease says only 3. You should have been released 2 years ago, but you weren't. You weren't. Why? Because the company doesn't want to give up your lease if they don't have to. My opinion. Whole show's my opinion. So what do? They want to, this is a classic example. They're going to continue to pay you shut in, even though the lease says they can only do it for 3 years. They're in year 5 now. Do you think they're going to stop in year 6? Heck no. They're going to keep doing it. And then they're either going to hit you with the document that includes the word and language ratification, or they're going to start producing. And once you start accepting checks, you'll now have ratified the lease, and they'll say, hey, you can't sue us now. You took the checks. And you're stuck under that old lease and no bonus, no new negotiation. So twice in the last few weeks, I've written letters saying, essentially, wow, what the heck here? This lease expired 2 years ago. And I am completely confident these leases are going to be released because they're clearly over. But the company kept paying shut-in payments and the people kept accepting them until they called Attorney Doug Clark, me, at the Clark Law Firm, 570-307-0702. They called me, Doug Clark, at 570-307-0702. And I reviewed their lease. I reviewed the drilling history. I reviewed the production records. I reviewed the DEP records and determined, hey, this is extremely clear. This lease is terminated. And so what do? We write the letter, terminate this lease. I've terminated multiple leases over the past year. I certainly expect that these 2 leases are easily going to be terminated. But if we didn't do anything and I didn't write this letter, it would have just continued. And the company would have attempted to address this, in my opinion, in one of 2 ways. I can't say which one most likely. But they would have presented a document that included ratification, include that language in a document, and the document may seem innocuous, unimportant, no big deal, but inside it is ratifications. And you're going to see these guys, and that's why I say when you get any piece of paper and you are asked to sign it, any piece of paper you are asked to sign, call my office, ask about a review and consultation. They usually take 1 to 2 hours for my review and our call or our meeting. I do most of these by telephone, but you're always welcome to come to my office. So regardless of your location, call me. I do these all myself, all me. It's what I do. Let's look at your lease, look at the drilling history, look at what's going on, and say, Should you sign this document? What's in the document? What is your leverage to negotiate? And I can tell you that these reviews have resulted, and this is, I don't like to do this, but I'll just say it's the truth, millions of dollars to people, landowners, as a result of 1 to 2 hour of reviews, how it starts, and say, look, your lease is over. Or there's no real claim to hold your lease, or I think your lease is over, and here's why. Or, hey, the worst thing that happens, unfortunately, this is something that's allowed to occur. You don't really have leverage, and this is a document that I would not have an objection to you signing, and it makes sense to sign. And you had it reviewed, you understand it, you spent 1 to 2 hours, and you know you're not getting took. And no one I know wants to get took. And we sure don't want to get took by the gas companies. And they're taking, in my opinion, taking people all over. They have been for decades, and certainly in Pennsylvania for the last decade. So we have to be smarter. So in any document, because again, ratifications can be buried, the language buried in any type of paper. Any document you get, put down the pen, pick up the phone, call my office, learn about it. And if you don't like it, don't do it, but I think you'll like it. Learn about reviews and consultations, and let's get to the bottom of it and make sure you're not going to make a mistake. My number, 570-307-0702. I promise I want to help you. It's all that I do. 570-307-0702. Give me a call. And again, I do these all myself. I don't care where you're located, but we have to stop doing this. And I'm going to give you examples, real life examples of how this is working, how it has worked, and what I see happening in the future when I get back. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you keep listening each and every week at this time on this station. We need to get this information to you, and call my office anytime, 570-307-0702. I work for landowners. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station for All Things Marcellus and the information you need regarding oil and gas development. And of course, and as always, I, Doug Clark, never have, never will represent oil or gas companies. I represent landowners, oil and gas right owners for such things as lease negotiations, pipeline negotiations, royalty and royalty deduction issues, all breaches or terminations of gas leases, pipeline agreements, estate planning for gas right clients. Also, unitization issues, surface use agreements, well pad agreements, any and all documents, contracts, issues related to oil and gas development in Pennsylvania. And regardless of your location, clients all across Pennsylvania and clients who live and have had clients who live all across the country and in other countries. Also, I've represented landowners with as little as 0.2 acres, maybe even 0.1, and as much as over 5,000, actually over 10, and I think even 30,000 acres. So give me a call the office, 570-307-0702. If you have any oil and gas related issue, or if you're presented with something in the future. I'm going to talk about these ratifications more in a moment. But again, I can't stress this enough. This has become, the whole oil and gas field now has become extremely tricky, where if you're not doing this all the time, you're going to be lost, in my opinion. You have to understand what's occurring in the industry and how these leases operate, how companies develop, how they drill, how they unitize to effectively represent people in today's climate, in today's situation. We have a very unique situation here where the gas, the price market and the gas market has crumbled. And so companies aren't producing and they're trying not to drill. And in my opinion, they're desperately trying to hold on to leases. And the question is, are people going to do nothing and allow companies to continue to hold leases which may have or have expired? Or are we going to do something about it? And I'm going to tell you this, that I, Doug Clark, I am going to do something about it as much as I possibly can with every person that I can help and that I can represent to stop this. Because I'm going to tell you, I've had already multiple successes. It's not like we're hitting brick walls all the time. We are able to and have had leases canceled and released. And we're going to have more done this year. And sadly to me, I know, in my opinion, there are probably hundreds of leases that have terminated or almost certainly have terminated, because there's arguments to be made. But there's some that are extremely clear, and there's some that are not as clear, but have terminated. And the question is, are we going to sit back and do nothing? Maybe people like getting $5 per acre per year for their lease that they were told they were going to be millionaires years ago, that the primary term expired 5 years ago, 6 years ago, 7, 8, 9, or 10 years ago. Maybe you like having signed a lease between 2000 and 2006, or 2007 or 8, and not get a dime of royalty. Maybe you like being held by a vertical well that's shut in, that's never paid a dime of royalty, that's not even connected to a pipeline. Maybe you like that. Maybe you like not being able to negotiate a new bonus, 1,000, 1,500, maybe 2,000 an acre. Maybe you like not getting that money. Maybe you would rather get paid 12.5% royalty with no additional bonus money instead of, let's say, $1,500 an acre, and increase up to 15% royalty. And also maybe other additional addendum terms which are beneficial to you. Maybe you like not having those things. Obviously, I'm being unbelievably sarcastic because nobody would like that. But we're letting it happen. And why are we letting it happen? Probably because there's a lack of knowledge or understanding, because people aren't telling you this. I am, and I try to scream this from the mountaintops, and that's why I say tell your friends, tell your neighbors, tell your dang enemies. Somebody has to be addressing this. The companies aren't going to tell you. I don't hear any other lawyers talking about this, but it's something that I'm dealing with every day. Every day. I sent 2 letters this week on cases which I am pretty darn confident we're going to terminate the lease. And had those people not called me, and had we not done a review and consultation, they would be continuing to get their shut-in payments and maintaining under this old lease. And I think we're going to stop that. So I think the reason why people aren't doing anything is they don't understand that they can. And if you do understand that you can, maybe you don't know who to call or what to do. And this is a good time to tell you, you're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can call me. I am here to help you, the Pennsylvania landowner. I want to help you. If you have a lease that you can get out of, I want to get you out of that lease. If you don't have a lease that you can get out of, I'm going to tell you, here's why your lease is valid and why I do not think you'll be able to get out of it. Again, those take 1 to 2 hours, reviews and consultations. If you have over 100 acres and you've been shut in for 8 years or more, I'll do that review and consultation for nothing. Call me, 570-307-0702. Get answers. Get answers. Get answers, and I want to give them to you. So let me take this. I want to reset here a bit. I'm going to give you an example. Okay, let me give you an example. So I just had a case that we took up to the Superior Court. This case actually originated out of Western Pennsylvania, but this can happen anywhere. So I'm going to give you just a basic factual breakdown. People signed a lease in 2003, that had what's called a 6-month primary term. Most people are used to a 5-year, maybe a 10-year, or a 5-year with a company option to extend the primary term by an additional 5 years. That's what most people are used to. But this lease had a 6-month primary term, signed in 2003. The 6-month primary term ended in December 2003. There was no production. There was no anything. The primary term ended, and it said in this lease that there had to be production or ongoing operations. Well, there weren't any. There weren't any. None. So what did the company do? In this case, I believe it was $3. They paid these routine $3 shut-in payments as required by the lease, which, in fact, in my opinion, strongly terminated because it was only 6 months. But they paid $3 per acre. And they made those payments from 2003 until 2010, even though the lease had a 6-month term. A 6-month term lease that the 6-month expired in December of 2003. That 6 months. That's how long that lease was supposed to be for, and there should have been production or drilling or continuing to operate in order to get production, but there was not. Instead, the company paid $3 from 2003 to 2010. Now, 2010, they're ready to drill. They want to drill. My opinion, they know dang well they do not have a valid lease because the lease was only for 6 months. They know they don't have a valid lease. So what do? Oh, hey, landowner. Now, again, this will be an exaggeration as an example. This is just me making this up. But this is how this goes, in my opinion. Hey, landowner, we want to drill. We want to make you rich. We're going to drill now. Oh, hey, we have this document for you to sign. And inside this document is the word ratification, is the language of ratification. And inside that document, they say, well, just giving somebody a ratification may tip them off. Ratification, what's this? Maybe I should talk to somebody like Doug Clark. Well, hey, here the company says, well, let me think. Let's give them a little something, and we'll, in my opinion, give them something and sneak in ratification. Give them free gas to their house. Give them a couple bucks. Give them something. Show them something shiny. Well, my opinion, well, you have the shiv behind your back. Shiny object. Don't pay attention to the rat over here. Pay attention to the shiny object. Get the people to sign, then say, well, we have a lease because you signed a ratification where you said this lease is still in effect and not in breach. And here's the deal, guys. I argued this case in the Superior Court in Pittsburgh and lost, arguing that ratification shouldn't have been effective because the lease terminated. Lost. That ratification, in my opinion, and per the court's ruling, killed this case. Killed or revived a dead lease. Ratification. Unbelievably powerful. In my opinion, using the market rates and things of that nature, for this property in this case, the new bonus would have been way in excess of $1 million. And I believe, and this is on memory, I think it's even in excess of $2 million. $2 million. My opinion, these people, if they called me before the ratification, would have received that type of bonus. They also, in my opinion, in this market at this time, had they called me, almost certainly would have went from 12.5% to 18%. But they didn't call, and that's okay. They didn't know. But that's the thing. We need to know. So if you get a piece of paper and you're asked to sign it, you are on notice. Put the pen down, pick up the pen, because this might be a problem and you better figure it out because you might be costing yourself literally millions of dollars. And the worst thing that can happen is you get a review and consultation and you didn't get took. That's the worst thing that can happen is you get good information and know you didn't get duped, fooled, or took. So call my office, find out about reviews and consultations on any document. I am here to help you. It's what I do. It's what I love to do. And I don't want to see our people taken advantage of. 570-307-0702. 570-307-0702. I don't care where you are. As long as that property is in Pennsylvania, call if you have anything. And let's see if I can help you. And again, let's get you the information you need to make the right decision. Keep listening to this show with me, Doug Clark, each and every week at this time on this station. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, as always, I do not, I will not, and I have not, never have, never will, represent gas or pipeline companies. I gotta be honest, I hope this comes across. I hope it really does come across. If you think that there's any way that I do, listen to a couple of these episodes and hopefully you'll figure it out. And again, this information is so critical and we need to get it out to people. If you missed the beginning of today's show, if you have friends, neighbors, or enemies who you think should know about these topics, direct them to my website and to this show, which I do every week at this time on this station. But direct them to pagasleaseattorney.com. I have two websites, pagasleaseattorney.com and pipelineattorney.com. If you are in Pennsylvania and you have a pipeline agreement presented to you, and you are not going to pipelineattorney.com, I ask you why. Go there, use it as a resource of general information, the radio show and the website, general information. But let's get educated and informed. That's what the companies prey on, a lack of education, a lack of information. They want to be in a situation where their landman, who works for the company, not you, the landowner, is the only one talking to you, who's the only one giving you the information. And that person is giving you the information that they want you to have, not the information that you need to have. They're giving you the information that the company wants you to have. I give you the information that you need to know to make the right decision. You have a company, multi-billion-dollar companies, who are sending trained people to talk to you, who do this all the time, who work for the company. You have to understand that situation. And like in my example, if these people did not sign the ratification in 2010 and they called my office, said, "Hey, Doug, can you do a review and consultation? We got these documents. We're not sure what they mean." Absolutely. Love to. Send me the information. Oh, you live all the way out in Armstrong County? Send me the information. We can do this by telephone. I'll review everything. I'll be prepared. We'll get on the phone. Whoever needs to be on the phone from your side, we can call into a number and we can all be on the phone and I'll explain everything. I'll tell you what your situation is, what your leverage is, and what you can do about it. And I'll tell you what you need to know. And in that case, I would have said, "Wow, thank God you called me." Because all signs are this is not a valid lease. And if you would have signed this ratification, you would have corrected the errors and the breach and the termination of this lease. And I would have stopped it. And then I anticipate we would have negotiated. And I believe that fully. And we would have, at the market times, obtained thousands per acre and significantly more royalty. But guys, what is happening And what gets me so frustrated and worked up is that I know it will and it does continue to happen. It's going to continue to happen. And we got to stop it. And if you're listening now, you have no excuse. If you're given a document and you sign it, you have no excuse if you didn't call, do a review and consultation. And I always say, look, call me or call someone who knows what they're doing. But I question more and more how many people know what's going on here. Many of these leases, I am convinced have terminated. Many. But unfortunately, people aren't going to do anything about it. People are going to sign these documents and give up the right to do new leases for new bonus, new royalty, new addendum terms, all of these things. Because why? The only reason is, one, they don't know. Two, they don't know where to turn. Or three, they don't like protecting their property and maximizing their financial benefit from the development of their property. And I'm going to tell you, I do not think it's number three. And that's why I say, I know sometimes, I believe that sometimes, and look, I'm the first person in my family who went to college, all right? So I believe sometimes that people are afraid to talk to lawyers, or afraid to call lawyers. Listen to my shows, get to know me. This is who I am, and I want to work for you. Don't be afraid to call my office. Look at our websites. Look at the 100+ testimonials we have on the website. And I could have more and more and more of them. Look at them. Read what they say. And decide, should I call this guy and do an hour or two of time and have a review and consultation? Because that's what it typically takes. And then decide, do I want to do anything else? Is it over? Am I getting taken advantage of? What are my rights? And I think you're going to find that it makes all the sense in the world to call. 570-307-0702. And keep listening to me, Attorney Doug Clark, All Things Marcellus, this radio show that I do each and every week at this time on this station. But most importantly, if you are given a document to sign, put the dang pen down. Put it down. Pick up the phone. Call the Clark Law Firm. Again, I do all of these myself. No associate, no one else. I do these. I work hard, and I love what I do. 570-307-0702. And for my entire life, since I was a kid, I don't go for people being taken advantage of. I don't go for that. And I want to fight to make sure that you're not being taken advantage of. And again, many people know. This is an easy area to say to people, I'm not making up people being taken advantage of. It is so unbelievably widespread that probably most of the people listening feel already that they were taken advantage of. Most, not all, but most people probably do. And if you don't think you were taken advantage of, if you live in a gas-producing area, I'll sure as bet you know somebody who they feel that they've been taken advantage of, and you probably know someone that you feel the company took advantage of your friend or the person you know. We have to stop it, and that's what I want to do. Call my office, 570-307-0702, 570-307-0702 on any document, the shut-in issues, ratifications, call. And keep listening to All Things Marcellus each and every week at this time on this station with me, Attorney Doug Clark. We got one more segment left, and I'm going to tell you, you're in Tioga County, stick with this. I don't care where you are, though. Stick with this. Great example. Stick with this. I'm going to teach you again. I'm going to show you, not teach you. Sorry. Well, yeah, I'm going to teach you another trick. Stay tuned. The dreaded top lease. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark, the Clark Law Firm. Remember, you can call my office any and all oil and gas representation, land owners only, oil and gas right owners only, 570 307-0702. You miss any of today's show, go to the website. We post it up Monday morning, pagasleaseattorney.com, pipelineattorney.com. I'm going to now talk about, and keep listening each and every week at this time on this station, I want to talk about now situation that occurs in Tioga County. You know, I talk about this all the time, these shut-in wells, these vertical wells that are shut in. If anybody can hear anything today, if you're in Tioga County and you have a vertical well that is shut in and you're part of that unit, again, as always, if you have 100 acres or more and been shut in for 8 years or more, I will do a free, no obligation, no cost evaluation to advise you whether I feel your lease is terminated. Anyone else can call if you want to find out, and I'll do a review and consultation at my regularly hourly rate, which usually takes 1 to 2 hours, and I will evaluate and we will talk about whether I feel your lease is terminated. You should be taking advantage of this, in my opinion, because, again, I believe that hundreds and hundreds of these leases have indeed terminated, but the company keeps paying you shut-in payments. If for some reason you don't do that, if for some reason you don't call now or call in the very near future, if you are ever given a document to sign, you should be picking up the phone and calling my office, 570-307-0702. I gave you the example that occurred in Western Pennsylvania of people who signed a ratification, and we got the Superior Court decision relying very strongly saying, hey, they ratified the lease. They said it's okay. We can't do that. These can be multi-million-dollar mistakes, hundreds of thousands of dollars mistakes. And it's simple to stop. Do a review and consultation. Find out what your rights are. If your lease is terminated, it may be really simple, or you can just continue to take these payments and be held under your lease and do nothing and miss out. Or you can spend an hour or two at a time and figure out what your rights are and where you stand. 570-307-0702, Doug Clark, Clark Law Firm. I want to talk now, Tioga County. I'm going to keep talking about this because I need to hear from everybody I can in Tioga County on this issue. And listen, you call my office. This is what we do. I want to hear from you. This is what we do. It's what I do every day. So let me give you an example. Person calls, says, hey, company has offered me what's called a top lease. I already have a lease, and my lease is about to expire, we'll say this summer. So we say, okay, well, you have a well on your property, and your lease is about to expire, and if you do not, and because your lease has a term in it that's going to expire this summer, and if you don't do a top lease, meaning sign a new lease now before your lease expires, your lease will expire this summer. And if it expires this summer, the company will no longer hold you or hold your lease. Pretty simple. But this will have a definite domino effect. What is that domino effect? If the company loses this particular lease, this lease has a well pad on the property. The company will now have to plug the well, reclaim the well pad, put it all back to the original condition. Well, that costs a lot of money. Companies want to try to avoid spending money if they can. So that's one thing. They'll have to pay all that money. Well, if you sign a lease, they can keep that pad there, and they don't have to reclaim it. And you're stuck again under this new lease just sitting there without royalties. And if you're going to sign a 5, 7, 10-year lease, you just authorize them to keep that pad there without doing nothing for another, let's say, 7 or 10 years. Bad decision, in my opinion. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. So the other probable domino effect, if the company loses this lease with the well pad on this property, they have the potential to lose all or many of the other leases that have property in the unit where this well pad is located. Let me explain. We'll say it's the Clark unit and the Clark property that has a well pad on it. We'll say I'm Clark. If Clark's lease ends, the company's ability to have the pad on my property is gone. They now have to reclaim it and clean everything up, and I get rid of this pad on my property. That's number one. I am also now a free agent to negotiate a new lease at any time or under any conditions I can intend to obtain. The next thing that happens is the Clark unit, say it's 640 acres, that was created because of the well pad on my property, the Clark property. Well, my well pad is now gone, my lease is gone, and therefore the Clark unit is now gone. And any parcel that is held or has been held or even has been argued to be held because that property had any acreage in the Clark unit, well, those leases have now also all ended and terminated because the Clark unit terminated, and if you are only held under your lease by the Clark unit, your lease is now ended too. So guess what? Clark has some leverage here. So company, if I don't sign a top lease, you have to clean up my property, reclaim the pad, plug the well, and you're going to lose a bunch of leases, and you're going to lose all the leases that are held solely by the Clark unit based upon this well. So when you come to me with the top lease, of a typical offer, 7, 10 years, whatever your typical offer is, me, Doug Clark, I'm going to laugh at that. If it's me, I'm going to laugh at that because I know you have a problem. I don't. You do. But people will just sign it. And then they now agree, let's say it was a 10-year lease. That pad's going to sit there another 10 years, and maybe you have a 5-year shut-in limitation. You just gave them 15 years to do nothing. Or you could have waited and played your leverage and maximized your negotiations, or worst case scenario, you allow your lease to terminate and the company has to reclaim, and if they ever want to develop you, they need to give you a new lease, and they're going to lose a bunch of other leases, and they're going to have to pay for those leases too. And I predict strongly the company's going to offer you more money. In my case, we're saying Clark, they're going to offer me more money. And I'm going to push them, and I'm going to maximize it, and I'm not going to get fooled, duped, or tricked because I know what I'm doing. And that's what we have to do, guys. Tioga County, if you were given a top lease, put the dang pen down, call me, 570-307-0702. Any document. This ratification, rat, is buried in many of these documents, and you don't even know it. And you need somebody who knows what they're doing to look at it. What's happening again, the gas prices have made these companies, in my opinion, very desperate, and they're doing very shady things, or gray area things, at least in my opinion, to hold these leases. We can't let them do that. We can't just sit back. And again, it starts with the review and consultation. If you have 100 acres or more and been shut in for eight years or more, call my office. I'll do a free, no obligation, no cost evaluation. If you are otherwise in a different circumstance, learn about reviews and consultations. They take 1 to 2 hours. But no matter what you do, keep listening to All Things Marcellus with me, Attorney Doug Clark, each and every week at this time on this station. And remember, the landman doesn't work for you. He or she works for the company, not you, the landowner. We need to stop signing bad agreements. Put down the pen, pick up the phone, give me a call, and remember, have a great, great week, everyone. See you next week.